Welcome to the third webinar in our fourth annual quarterly perspectives on tax law series, Managing Tax Disputes, fall update on recent development and trends. My name is Marie-Claude Marcil, and I am a partner in Fasken Tax Group in our Montreal office. And I am joined today by my partner, Tim Fitzsimmons, who's located in Toronto. And we are both specialized in tax litigation and controversy across Canada. Before we begin, because we have a lot of interesting things to cover today, I'd like to draw your attention to the fact that this webinar can be used for CPD certificate credits in Ontario, Quebec, and British Columbia. You will have a QR code at the end of this presentation that will give you more information on how to get your certificate. And there's also going to be a link to a quick survey. So we would be grateful if you take some time and provide any feedback. Now, thank you for joining us. And without any further ado, let's get to it. Tim, could you present our agenda for today's webinar?
Yes, gladly. Thanks, Marie-Claude. Welcome, everyone. Good morning, good afternoon, wherever you may be. Really glad to be with you and talking today about some recent updates in tax disputes and tax litigation. For those of you I've chatted with before, you've sometimes heard me say the phrase, what a time to be alive in tax, and what a time to be alive in tax dispute resolution. We find ourselves at quite an interesting time for the country and for our tax system and its implications for tax disputes. And we're going to talk a little bit about all of that when we're going through our presentation today. On our agenda, we do have the current enforcement environment, so we'll talk a little bit about what's happening with the CRA. Recent developments in the areas of some of the legislation, big announcement a couple of weeks ago on voluntary disclosure program, and there's been a tremendous number of recent cases from the tax court and federal court of appeal and federal court as well that we'll get to. And we'll spend some time talking about AI and tax audits, and then wrap up with some best practices and some Q&A. So I offer the following caveat, which I usually do in these presentations. What we're going to cover today is an inch deep and a mile wide. And so Marie-Claude and I invite you to connect with us afterwards if there's anything that piques your interest. We've designed our presentation today with a lot of references to some of the source documents where we're finding information and data. We won't have an opportunity to go on a super deep dive on all of this. But as I say, we want you to have some takeaways here. And so please feel free to investigate, and we'd be happy to continue a conversation with you on all of that. So let's move right into it. And Marie-Claude, back to you for the current enforcement environment, a little bit of an update around the CRA and some recent statistics and data.
Thanks, Tim. And we forgot to mention it, but please, we'd love it for this webinar to be interactive. So feel free to ask any question. We'll definitely try to answer them to the best of abilities, but if not, we'll connect with you afterwards. So we always like to provide some current statistics on federal deficit and staffing because, in fact, they directly impact what we see on the field and what to expect in the next 2 to 4 years in terms of audit activities and obviously tax controversy and litigation. I won't go into too much details, but this slide provides a comprehensive update on key Canadian federal fiscal and tax administration metrics of 2025. We tried to find the most recent ones. Obviously, we have a new budget coming in November, so we don't have those numbers yet, but we note that the federal deficit for the fiscal year 2023-2024 was recorded at $40.1 billion, and that although the government had projections to reduce it by 2028 by 20 billion, I think, we know that that's a bit optimistic because the most recent numbers we got for 2024-2025 is that the deficit actually grew to approximately 20 billion. Now, we can certainly expect that its reduction will continue to be a priority, but what this tells us is that the government is in dire need for money, and that the best way to raise that money is through taxes. So how this translates in practice is evidently more audits, but also speaking from experience in the last 2 years is that I've also seen a lot more draft reassessments being issued and amended within the audit process. And while these figures reflect the government's ongoing efforts to stabilize public finances while maintaining essential services, we can see from the tax gap, which represents, as you know, the difference between taxes owed and tax collected, that certainly collection measures have been working, reducing the gross tax gap by 39 to 45%. And I can tell you again, on the field, we have seen collection efforts significantly increasing. However, the government keeps implying that each dollar invested in CRA yields about $5 in revenue. But let's just challenge this metric a little bit, because this TIBA, as they like to call it, does not take into consideration the amounts that actually get canceled at objections or appeals. And before I get into my theory behind what I've seen as an increase in the issuance of ill-founded reassessment, there's an important statistic that is not reflected on this slide, and that was actually in the Globe and Mail this morning, which you've sent to me, Tim. Do you want to comment on that before I move on to CRA staffing?
Yeah, absolutely. Well, I mean, as we say, things are moving pretty quickly in tax disputes these days. And there was a report in the Globe and Mail of a private member's bill regarding the potential requirement of creating a taxpayer forgiveness list. I believe that there is a perception potentially among some of our political leaders that the amounts that were published in last year's public accounts around the amount forgiven or written off by the CRA in terms of tax debts was inappropriate, and there appeared to be some basis or data that said that there was a very, very small handful of large taxpayers that received quite a significant amount, in excess of $1 billion of tax forgiveness or write-offs of the tax debt. So I can tell you very quickly, I took a quick look again into the public accounts. The data doesn't support some of the headlines that you see, some of the sort of basic information that you see in some of these news reports. So I guess it's just always a caution. On one hand, we know that our political leaders, are taking a look at this to ensure consistent application of enforcement across the country. On the other hand, sometimes we do need to take a deep breath and just go back and look at some of this data and unpack it a little bit to try and figure out how the CRA is performing in terms of its operations and whether anything needs to be improved in terms of process and disclosure.
Thanks, Tim. So if we look at the numbers, like you said, in terms of staffing, we actually know that in 2025, there were approximately 52,000 individuals employed officially at the CRA, and that marked an increase of about 31% since 2017. And we have definitely seen this increase in practice, especially, I would say, since 2021. However, and this is again purely based on my experience and discussions that I've had with other professionals on the market, there was a very important increase in CRA staff. That's 100% true. But presumably there may not have been the required training given to ensure the quality of the services, because we've seen, some issues in that regards, especially in the last 2 years. So in this context, and with the new audit powers that we will address later on, I think there will be a shift in how taxpayers perceive and deal with audits in the future. If we move on to the next slide, recently in the news, because of the government's budget reduction mandate, which was previously announced to require 15% budget cut across departments, including $715 million for CRA alone by 2028, 2029. We've heard that unions have come out and estimated that there's already been an important reduction in staffing of about 13%, and only in 2025 alone, 2024 alone, there was 7,000 employees who lost their jobs. So it's too early to see an impact of such cuts. But we've, detailed the branches that it may affect, and also the regions. We'll keep an eye on that for our next webcast, that's for sure. Moving on to the next slides, some details specifically on audit and objections, because I've get these questions a lot. It was published that CRA conducted approximately 69,000 audits in 2023-2024, and that the focus is still on aggressive tax planning. I also noted that CRA had an important increase in objection, and actually an increase of 35% just in the last year. I have not done the math, but I would be curious if this increase is in line with the increase in completed audits. We also note that processing time of objections have not gotten better, unfortunately, and this is rightly so in line with our own experiences in practice, but still taking more than a year for median complexity income tax objection that the CRA mentions. I would say a bit more than that, but certainly for large complexity objection, we don't have any statistics that are recent, but I always tell my client to expect 2 years approximately to get a decision, and that is not when ruling has to get involved. And finally, what I'd like to mention is that CRA saw a growth in taxpayer relief request as well, and that aligns with what I've been doing in practice as well. If we move to the other slide, some good news now for the Tax Court of Canada. We have now a full court of 27 judges. So this is 7 new judges that were appointed last year alone. We have already seen recent appointed judges render their first decisions. I'm thinking of Justice Sorensen that has rendered a couple decisions during the summer. So this is certainly encouraging. These are just other statistics for your own information. I thought it was interesting to note that 45% of the appeals are actually being filed and heard in Toronto. And when we called recently at the Tax Court of Canada just to set a 3 days hearing in Montreal, it brings us to 2028, the end of 2028. So I'm assuming in the Toronto region, it's even further than that.
Yeah, it is quite delayed in Toronto. I can tell you that on at least one file, we've put in a request for hearing dates that went in at least a year ago, and we don't have a response from the registry yet. So there continues to be some resource challenges there, which I think I understand the tax courts administration is dealing with the federal courts administration service in terms of that. And just on getting access to court, I believe in Toronto, the court is looking at expanding to add additional courtrooms because of the level of activity there. I think regrettably, the court was conducting hearings in Hamilton, but they had to close that court location because of some security concerns. And I believe that there is a plan underway to renew or expand the Montreal facility for the tax court. So hopefully some actual just additional square footage may assist in creating opportunities to get some of these cases, those that need to be heard, into the spaces that are required in each of these centers.
Yeah, absolutely. It's definitely encouraging. If we look at the access to information questions and requests that we make, unfortunately, no good news there. It still takes a lot of time. So that kind of ties in on our best practices that we'll discuss later on. But definitely, if you know that you have to wait almost a year to get access to some of the documents that were provided during audit or objection. Maybe a lot faster if you have them already on file and really well identified. And just a quick apartheid, in Quebec, the process is actually very, very fast. So I'm hopeful that when making an ATIP in the future, this delay will go down, because if we look at the next slide, just visually, we can see that it's mostly because the requests have gone down that it's been getting better. So a lot of things to work on in that department. So let's go to recent developments in the legislation, Tim.
Yeah, great. Thanks, Marie-Claude. And I would just, before we leave the information requests, I always mention this in my presentations on this point, but the CRA has a technical or a published view on this, in which the CRA expressed a preference for taxpayers or tax professionals to actually directly make informal requests to the CRA. So to the extent that you ever need to obtain information from the CRA's preference, publicly stated, is that they just ask you to ask them informally outside of an ATIP request. Now, to the extent that you may get some pushback, it might be helpful to remind whoever you're dealing with about this published position. But again, some information would be outside of either your direct file that you're dealing with, or you're looking at some other issues that would require an ATIP request. And of course, you have to go that way as necessary.
And we had a question in the chat, Tim, whether we had the specific statistics for British Columbia. I don't think they are publicly available as easy as the ones that we got at the federal level, but we could certainly check and get back to you.
Yeah, gladly. Vancouver being a very, very busy center for the tax court, but I don't recall off the top of my head the data around the recent caseloads and hearing dates and things like that. All right, so let's turn then to recent developments on legislation. Obviously, we have spoken in previous webinars, and we've published on the enhanced audit powers that the government announced in April of 2024. I think that if you had asked any tax professional prior to April of 2024 to provide a list of areas for suggestion for improvement in our tax system, I don't think any of us in the tax disputes area would have suggested that the CRA needs more audit powers. However, we have these proposals, and it's fair to say they appear that they're moving forward in substantially the same form that they were released in 2024. The August draft legislation update has few substantive changes. The ones that are of note is that the new non-compliance penalty under proposed section 231.9 does contain what you'd think of as an off-ramp in terms of the taxpayer's reasonable belief that they were not required to disclose the information because of solicitor-client privilege. I would suggest that, number one, that's an appropriate amendment to the legislation, but number two as well, to the extent that if that hadn't been included, I think a constitutional challenge of any of these provisions relating to the potential sort of urging by the CRA of disclosure of all materials, and to the extent that that could have started to creep into solicitor-client privilege materials, it wouldn't have withstood a challenge, given the jurisprudence that we've seen from the Supreme Court on the importance of solicitor-client privilege to a properly functioning legal system. The quasi-court, sort of court-like process around oath and affirmation process, the CRA has this proposed new power in proposed 231.41 to compel employees, officers of a taxpayer, or a taxpayer individually to provide a statement under oath or affirmation. Very, very broad and unusual power. We're not exactly sure specifically what the guidelines or guardrails around this type of process might be. I can tell you that in some previous experience, I've seen this for clients having to manage through a criminal or quasi-criminal process, and the process that we sort of went through with the CRA there on a criminal investigation related to something other than what the taxpayer was dealing with, but a broader investigation. The process there was getting people in the room, 2 CRA investigators with a computer, a laptop, and a printer beside them, and then statements were taken and nearly verbatim recorded in a document. It was printed out, and then the CRA hands it across the table to provide it under oath or affirmation. So I'm not sure if that type of process will be utilized here, but certainly, we caution all of our clients to the extent that in the future, any of these powers may be suggested or used or proposed in the course of an audit, that it will be appropriate to understand all of this, how this will be used, what the expectations are, and then probably as well, counsel would be required to be involved. And I know that certain other commentators, and I'll mention this as well because I think it's a great point, certain other commentators have pointed out that to the extent that the CRA intends to use this type of audit power, they'll probably have to revisit their general policy that they do not allow recording of any meetings with the CRA officers or employees, because to the extent that there could be a dispute around what exactly goes into the contents of an oath or affirmation, and if you're being held to a particular position, well, I'm sure that you probably would want to consider what sort of recording is in the archive for that meeting. And then the compliance order penalties, a modest adjustment there relating to the potential disproportionate or unfair size of the penalty. There is some now discretion for the minister to determine that the penalty is too great or disproportionate or unfair. And also there's another off-ramp for solicitor-client privilege. And again, all of these, in terms of trying to keep all of this in mind, there are proposed changes as well to when the normal reassessment period will run and not run. And it's worth having to keep an eye on all of that. Generally 3 years, 6 years, there's it was a little less confusing to have to calculate it, because now it's possible that there's going to be a lot of moving parts on all of this of when the reassessment period is running and when it's not. So we've got to think a little bit more about all of that. And as I say, no significant changes from the previous draft proposals. Now, like Marie-Claude mentioned off the top, we're about a month or so away, a little more than a month from the next federal budget from this new but the same government. And so we'll see what is introduced in that budget. I just included here a couple of possible reading references for those who care about such things. Again, getting back to the point about a focus, apparently in terms of CRA enforcement as to whether we needed to be spending our political capital and energies on drafting proposals that relate to expansions of the CRA's audit powers. We're at a critical time, in my view, around our tax system design, and what we as a country likely need to be doing around ensuring our financial and economic stability and success into the future. And so Bank of Canada officer Tiff Macklem gave a speech just earlier this week in Saskatchewan about some of the what he called global mega trends, and in particular, significant changes in global trade since 2010. So there's some suggestions there as to what we're dealing with, and that could give us a recipe as to how to manage the Canadian economy and Canadian finances going forward. And for those who really want to go quite deeper on some of the data and statistics, RBC published a report in 2024 about lagging Canadian growth and productivity rates. And so these are the big ticket issues, it would seem, in terms of tax reform, tax simplification, creating a made in Canada solution or made in Canada solutions around how to deal with these budgetary issues. So we'll find out what, in terms of the CRA's the existing proposals around CRA audit powers, what those may look like when we start to see some budget documents and some statements from this government about what they intend to do.
Tim, before we move on to the recent developments for voluntary disclosure program, I just want to mention a couple comments on the draft legislation. I 100% agree with you. This is going to constitute a huge shift in the way we deal with audits. And no, the draft legislation has not received royal assent, but I can tell you that we've seen letters already highlighting non-compliance. And the wording that is being used on these new letters are very much linked to the new draft legislation that has not received royal assent. So all that to say that CRA is ready. We've seen them already putting that forward. So it's something to really think of when you deal with new audits. It's a total shift in the way you manage them, how your team manages them, and how we take a strong look at what is requested as information and how we respond to them because of the consequences that will go with those non-compliance, let's just say.
Yeah, absolutely. That's a great point, Marie-Claude. We can, as an academic matter, study these and try to understand how they're going to work. But really, where the rubber hits the road is once we see this in the field. I think that as tax professionals, we see examples of unusual applications or interpretations, both of the substantive provisions of the Act itself and also the use of the audit powers, and certainly even in sort of previous cases relating to compelling disclosure and documents that might be held outside of Canada and other jurisdictions. I've seen some unusual audit activity that would appear to indicate that the rule or sought to be relied on was being used in an unusual way. So I agree. I'd be curious to see how all this unfolds for taxpayers and for tax advisors in the next year or two. All right. So with that, let's turn then to our next area, the voluntary disclosure program. And I'm going to talk a little bit about the specific updates in a couple minutes, but just want to take the opportunity here to actually provide a little bit of a sort of historical, sort of quick rundown to provide a little bit of context actually for why we may be seeing the development that we've seen as of September the 10th, when the CRA announced the new proposed changes that we're going to see in Information Circular 1R7. So very briefly, there's a couple of really, really good articles on the history of the VDP if you wish to do a dive into all of this, including one by now Justice John Sorensen, but the Canadian Tax Foundation has some excellent historical materials on the VDP program. In any event, back in the 1970s, when they introduced the program, it was really tied more as a bolt-on to how the CRA was dealing with tax evasion and aggressive or improper tax minimization. And you had a program that was, in its nascent form, very sketched out. I think that both 70-9 and the first versions of 85-1 might have been 3 or 4 paragraphs long. There was not a sort of full development of the program as it came to be known in later years. And over time in the 70s and 80s, that program started to get more and more narrow until the CRA decided that actually the best use of audit dollars was to actually expand the program. And so we saw the introduction of some more specific rules around no-name disclosures, the basic outlines of the requirements coming into focus around voluntariness, completeness, penalty, 1 year past due, all of the things that we can think of in terms of the program now. That then probably went into a phase 2 that was more expansive, having those types of components in it. Now, when we get into phase 3, which I'll talk about in a second, here we saw a significant narrowing of the scope of the VDP program, going from the no names and everything else that went along with it, and what appeared to be a successful and well-functioning program. But there were significant changes made in 1R6 that limited the program to a general program and a limited program. The no names program went away. And so there was what you'd think of as a significant narrowing. And obviously, historically, we had the introduction of 223.1 in the early 90s. Now, the statistics are a little difficult to find, and I confess I had to cobble these together from various sources. So it felt a little bit like comparing apples to oranges when I was trying to pull information from various sources. But what we have here are some examples of the statistics that I could find around how the program was operating for pre-2018. And you can see a growth in the program. You can see the adjustment dollars there. You can see significant numbers of these disclosures going up in 2014, 15, up in 2017. And as we'll talk about in a second, it might have been because the CRA at the time was very publicly talking about offshore compliance and enforcement, which probably led some taxpayers to be a little more diligent in just understanding where their foreign assets might be. Were they sure that they were reporting everything? Were they tightening the screws on their compliance with the assistance of their professional advisors? So just worth pausing as well here to think of what was happening about 10 or 15 years ago around the CRA's approach to international tax enforcement. There are publications such as the OECD's High Net Worth Individual and Tax Compliance publication, which if you go back and take a look at it, is nearly a playbook that we can see having been carried out by the CRA in Canada sort of post 2009. Other initiatives that were undertaken around that time, 10, 15 years ago, the CRA's Offshore Tax Informant Program from 2014, the Common Reporting Standard being introduced in 2015 and 2016. The CRA went so far as to constitute an Offshore Compliance Advisory Committee, and there was the establishment of the Joint Chiefs of Global Tax Enforcement in 2018. So you can see where all of this is heading. At the same time, we had these disclosures internationally from leaks from professional services firms of a collection of papers known as the Panama Papers, the Paradise Papers, and later the Pandora Papers. So when you look at the changes that showed up in IC 1R6, I think what it's fair to say, and I remember talking to some colleagues about this at the time, when I was expressing some regret about a narrowing of the program from sort of phase 2 to phase 3, the view that others reminded me of was that the CRA at the time thought that in respect of international and global non-tax or tax non-compliance by Canadians, we're going to find you. And the usefulness of the voluntary disclosure program might have, from one perspective, reached its limits in terms of its usefulness, because the data that was expected to be rolling in, the millions of documents that the CRA was going to have access to in terms of its enforcement, all of these other initiatives were believed to be, I think the assumption was at the time, we're going to find all of this stuff. And so either the taxpayers had disclosed up to 2015 and 2017, which we can see in the data. That is in some parts what happened, but that the disclosure program was no longer going to be required, and that tax, interest, penalties, this was all going to be something that was on the table because non-compliance was going to be discovered in some way because of all the access to this data and information that the CRA expected it was going to find. So did we find that the data supports that theory? Well, in 2018, disclosures were down 34%, and 2018 is a part year in terms of these disclosures. However, we have a 34% reduction from around 18 or 19,000 disclosures down to about 12,000. And if you go back as well to look at what the CRA has said about its audits resulting from the Panama Papers and the Paradise Papers, where there was believed to be somewhere in the range of 3 to 5 million documents in those databases that either related to individuals or Canadian entities in some way. What appeared to be a treasure trove apparently resulted, as of 2022, 265 audits with adjustments of additional tax collected in the range of 75 million. And then a couple years later, it was updated to about 310 audits with a little bit more tax collected. And the Paradise Papers having smaller numbers with a much, much less amount of tax collected. So I think you can look at this data and you can draw the inference that what it shows is that Canadian taxpayers are, on the whole, substantially compliant in respect of their non-tax or their non-compliance for other jurisdictions. And so whatever the operating assumption was, whatever the organizing principle was for the CRA when it was approaching the operation of the voluntary disclosure program in 2017, 2018, the data appears to show that Canadians take their tax compliance obligations seriously, that they were compliant, and that you had accidental non-compliance that could be corrected in some way, because certainly the data is not showing that there was a treasure trove of non-compliance that was discovered in the Panama Papers.
And Tim, if I may, the VDP program has had a bad reputation. It hasn't been advertised as an easy way to get tax money, right? And I think with the cracking down on aggressive tax planning in the last 5 years, it wasn't very popular to think about, going back to a more extensive VDP program that allowed for more disclosures. So I was actually taken by surprise with this phase 4, which I'm assuming you're dealing with after on the next slide.
Yeah, that's a good segue into exactly what I was going to talk about. And I think as professionals, for those of us that deal with these disclosures or potential disclosures in the area, you could also see anecdotally some examples of the ways in which the uncertainty around the program and the narrow scope of the program created far fewer files that actually proceeded with a disclosure if a disclosure was appropriate. So there clearly was the data that shows it, but I think anecdotally as well, some of us could think of examples of situations in which a disclosure may have been warranted, but the taxpayer may not have chosen to go that way. So that leads us all to phase 4. And on September the 10th, the CRA announced the changes that we're going to see in Information Circular 1R7. Importantly, on the voluntariness requirement for a valid disclosure, the CRA has now said we're going to allow some more flexibility, and this is welcome. I think you have prompted and unprompted applications. In the old sort of days, pre September 10th, if you had an enforcement action, if you had an existing enforcement action, that could invalidate your disclosure. And if you've ever gotten into a fight with the CRA about what was an enforcement action or not, you know that they took a very, very strict approach to that. A simple phone call could possibly end up having your disclosure bounced from the potential relief available under the program. Well, now it seems that the prompted and unprompted streams will still allow for eligibility with some relief curtailed in certain circumstances. And again, I think it appears to be a very fair way that this has been crafted. So unprompted meaning what we'd think of previously as no existing enforcement action in any event. The prompted now meaning where there was some verbal or written communication from the CRA that might have snapped a taxpayer to attention to say, I need to investigate this further. But it's not just prompted as though there was a CRA call. There also has to be something in the taxpayer's file relating to an error or omission that the CRA is aware of, or that there was a deadline to correct that needs to be met, or that the CRA has existing information, again, back to the Panama Papers. And if you've ever seen a disclosure from the CRA on a VDP application, you know that you see in the audit file or the file that they send over to you that they check. They check the taxpayer names and they check the entity names against the databases that are available for checking what's in the Panama Papers and the Paradise Papers. So they're still checking for that. The relief that's available if you're going into one of these two streams is going to be a little bit less unprompted. You're going to have the higher level of available relief, and the prompted, you'll still be eligible for the program, just slightly less relief may be available to you. The CRA has been a little bit clearer about how to deal with some of the years for domestic non-compliant, tax non-compliance. The CRA is looking at the most recent 6 years. Internationally, they're looking at the most recent 10 years. The CRA has said in the middle of all that, if you have some years for which there is no non-compliance that needs to be addressed, you can leave them out. The RC 199 form, which I think many of us as a matter of course just included, and you have a cover letter that has all the facts and circumstances and information, but we always included the RC 199 in any event. Now it was not mandatory last go around on IC 1R6. Now it is mandatory. So some observations here. Again, I think this is a welcome development in terms of creating a flexible program. This appears to be a cyclical development where we had a narrowing earlier on, then an expansion, then another narrowing. Maybe we're getting it right. Maybe the data will show that the best use of audit dollars is where the taxpayers are self-reporting in our system, including, discovery of innocent or accidental non-compliance. And so that's the best way that the CRA can be raising money. So this program should have a continuing useful life and purpose. So I think it's for the additional prompted, unprompted, I think can be very helpful. Curiously, these changes apply as of October the 1st. So we've got a narrow window here, but query whether you want to go under the old program or under the new program. So that's the first unusual aspect of this. It wasn't effective as of September the 10th. CRA says we're going to administer this program for disclosures made on or after October the 1st. The other issue that arises, to the extent that you may have a disclosure that's in the system and hasn't been decided on yet, or that was recently decided, but that possibly would have been entitled to relief if it had been made after October the 1st. I think there's a little bit of a gray area there, frankly, from an administration perspective as to how to handle some of those files. So we'll see how that gets dealt with, and maybe actually in a judicial review of some sort, the federal court might have to tell us. No names disclosures, still not available. That was a part of the program that seemed to work well for the administrative efficiency of making sure that you could make a disclosure very, very quickly. And for any professionals on the call that have had to deal with preparing the disclosure, that many of the accounting sort of processes, the forms, the returns, the calculations, those can take some time. If you delay your disclosure, there was always a risk that the CRA enforcement action could arise in the meantime. So the no names was very, very helpful because at least you could plant a flag on the effective date of disclosure. We still don't have that available here. I talked earlier about the economic efficiency of using CRA tax dollars in the most efficient way. Voluntary self-reporting of accidental non-compliance is, again, going to be the easiest way for the CRA to raise dollars. And the other area that I can tell you that I've seen around recent VDP applications is actually on the completeness side of things. And so enforcement action voluntariness was always an issue. This doesn't deal with anything in terms of completeness. And where that gets to be problematic sometimes is because the CRA will create a long laundry list of things that they ask for that they believe should possibly be included in the disclosure, or that they may say that we need to take a look at as part of the disclosure. And if you don't provide it, the CRA will just bounce your disclosure application because they'll say it's not complete. So that seems to be strictly enforced, and it can be problematic because the CRA's laundry list of what they're asking for may not be relevant to determining the nature of the non-compliance and the extent and the calculations and things like that. All right. So that's the update on the voluntary disclosure program. So let's move to our next area. Recent developments in the cases. And as we said,
a lot of them, right?
There's a lot. And we included these because, I mean, pick the area you work in, pick your area of interest. There's a tremendous amount of activity in these areas. We're going to talk about a couple of cases very briefly of interest, but really some interesting developments. We're going to talk about Chevron in a second. Settlements and privileges have come up. Some procedural issues relating to the contents of replies and evidentiary burdens have come up recently. Rectification, which all of us might have thought may not have had much of a future in Canada post Fairmont and Collins Family Trust, but I can tell you I still in my practice continue to see rectification, and we're still getting rectification decisions out of some of the provincial courts. So maybe we're getting towards the time when we need to review those two decisions of the Supreme Court, because certainly curtailing the availability of equitable remedies for tax mistakes didn't mean the tax mistakes went away magically. We still need to figure out how to deal with tax mistakes in Canada. For our tax system to function properly, we need to have off-ramps for resolution, and equitable remedies worked well for a long time. So we're still trying to sort that out. We have some GST decisions on there. Judicial review continues to be a very active area. There's a very important case in Harvard Properties on Section 160. Flipping to the next slide here. Recent decisions from the tax court on Justice Bodie and the Taves decision regarding proof of penalty. We've got this was the Amway case, the Seneca case regarding personal improvement element of business activities. Evidentiary cases, always critical. We've got deductions relating to tax arrears. And then the GAR cases we've included because these are cases that are going to be either have been or will be appealed on the basis of sort of a post-Dean's Knight framework. And so it's always going to be curious to sort of see what we're getting from the courts as they apply a Dean's Knight type approach in terms of the GAR analysis and framework and achieving functional equivalence of what the legislation may have sought to prevent. Again,
and sorry, Tim, and under the old GAR, right?
Yeah,
so,
and under the old GAR.
Exactly. It's going to be interesting to see whether the courts are going to take some wording out of the new legislation or how it's going to, impact their reasoning.
Absolutely. We're a long way from Canada Trust Co. from 20 years ago. So, taking a look at where these GAR cases are taking us. So, as I say, we're going to take a look at a select number of cases here with some observations. Marie-Claude, why don't I turn it over to you for a quick discussion of the Chevron case?
Thanks, Tim. And with the list of cases that you showed us, I can say that this year has been very prolific, and especially for administrative questions, meaning interlocutory motions. And Chevron is a good example. So quickly, what happened in Chevron is that in the taxpayer's notice of appeal, they had included facts that related to what had happened during the objection process, and the fact that during the objection process, the file was referred back to audit for further analysis. And these facts provided, if you want my opinion, mainly context. It did also provide some details on the result of this referral and the fact that notwithstanding the recommendation by CRA audit, the fact that CRA appeals had not allowed the objection. So you'll understand that the Crown took issue with these paragraphs and filed a motion to strike on the basis that these impugned paragraphs were improper as they went to the minister's mental process, and therefore they were irrelevant. Unfortunately, the court granted the motion and struck those paragraphs, and And the court agreed with the minister, saying that it did go to the mental process. But if you look at the jurisprudence, to me, it's a bit of a stretch of what constitutes the minister's mental process during audit and objection. There was nothing inflammatory in the allegations. It was just really plain reading of the facts and kind of a timeline of what had happened. And I can tell you that much, this jurisprudence has been used a lot lately by the DOJ to take, I would say, a harsher view at the pleadings and putting, again, it takes a toll on the taxpayer because the process is already long if we have to, argue interlocutory motions on striking some of the paragraphs. This is not in the interest of justice, in my opinion, if it's not inflammatory. So these are my 2 cents on Chevron.
Yeah, and if I could add to that as well, Marie-Claude, typically these arise because there's some aspect of the audit and assessing process that, as a matter of fact, involved some discussions that are later disclosed and that may have indicated that internally within the CRA that there were different views as to how to move the file forward. That's a matter of fact. So query, whether in crafting a pleading that goes into the tax court, reciting something as a fact that happened is so improper that it actually should be struck. Again, at the end of the day, it is the taxpayer's pleading. So should we really be getting into the business of circumscribing the opportunity to describe from the taxpayer's perspective, what is the case that, as we understand it, so that we know the case to be met here, and we know that these are the facts that happened in the assessing process. Ergo, we're mentioning it because it was a fact that actually happened. Now, I know that Chevron, as far as I understand, has not been appealed, and there were some comments in the decision regarding whether the actual concerns about limiting discovery were actually sort of real or perceived. And I'm curious as to whether we may not be finished with this case because it will go through discovery, presumably. And to the extent that the taxpayer's pleading was required to be reduced in some way, whether the actual limits that may come up around exploring issues in the context of discovery may require the parties to go back and revisit this, because certainly the court in this decision didn't think that the potential sort of limited impact for discovery was something that that would require that portion of the pleading to remain intact. So let's move on quickly then to Oldcastle Building Products. And actually, this is an example of a little bit of tension now that we're seeing directly with the Chevron case. This is a GAR case that will eventually be sort of more fully explored by the tax court once they get further on into the proceeding. But they had a procedural decision here about the Crown's request to amend its pleading to include a alternative basis argument for the assessment on the basis that the thin cap rules applied to reduce the deductibility or eliminate the deductibility of certain interest, cross-border interest. The minister's initial assessing position was that the GAR applied in respect of this cross-border reorganization, with the result that this adjusted paid-up capital that had arisen in the context of this and was not ground under 212.1 was reduced to nil. Certain cross-border interest payments were attacked on the basis of interest deductibility under 21C, pretty standard, straightforward stuff. Very, very late in the process, the minister came forward to say, oh, we've actually thought about it, and now we're going to support the assessment on the basis that the thin cap rule applied. So there's a GAR determination to be made later on down the road in the fullness of the court's exploration of that GAR issue. But in the interim, the question was, can the Crown amend its reply? And this was resisted, obviously, by the taxpayer. The tax court, having to interpret 159, gave it a very, very broad interpretation and said, really, at any time, an additional assessment or basis or argument for the assessment is appropriate, and the minister can make those changes. And in particular, there was some previous tension in the case law about whether raising a new issue or a different transaction or identifying a different business, a source of income, could be an appropriate limit on 152.9. But here the tax court says, no, essentially what the minister is doing in supporting the assessment is you're supporting a number. And accordingly, whatever arguments or basis you want to come up with, 152.9 allows you to do that post-audit, post-objection. You can do that in court. And getting back to Chevron, you're saying, well, you taxpayer need to limit what you're focused on in terms of what you can ask the minister about and the case you need to meet. And now 152.9 says it's actually not about arguments. You're actually just supporting a number. So I find it's a bit of an unusual tension that may exist in the law at this point because of the breadth that the tax court interpreted 152.9. Now I'm conscious of time, so why don't we just deal with quickly Shopify and Bank of Nova Scotia, and then we'll dive into some AI stuff.
Yeah, absolutely, Tim. Just quickly, Shopify, it was a big saga. And if you look at the decision, huge decision, basically the CRA issued an unnamed persons requirement and sought the court's authorization to do so. But in that requirement, there was a lot of confusion as to what they were targeting. There was a laundry list of things that they were looking for, but we couldn't even identify the group. So this is a cautionary tale to really, if you ever are confronted with such requirements, to really look at the jurisprudence and to ensure that, the CRA's test is met. Because with the new audit powers, if we receive, I would say sloppy requests like this, we have the obligation to challenge them. So those are my, again, 2 cents. If we want to move to Bank of Nova Scotia, Tim, I know you're following this one closely.
I am, and I'm just going to pop this slide forward here. There we go. Many of us who were following the case, if you were like me, you were a bit surprised in May of this year when you saw that the Supreme Court had granted leave. In some respects, you can look at the Bank of Nova Scotia case and say, really, it's about the timing of the calculation of interest. And if the Supreme Court's not going to grant leave in a case like Glencore, where there was, I think, broadly applicable commercial principles, that even though you could argue about the correctness of the lower court decision in the Glencore case, there was likely some tidying that perhaps needed to be done on an issue of national importance in terms of Canadian M&A activity and how certain of these contracts and provisions are to be interpreted. But the court didn't grant leave in Glencore, but yet here we were in May of 2025 and seeing that the court granted leave in Bank of Nova Scotia. So as I say, the narrow issue in the case was really the timing of when you're calculating interest due on an amount owing. In this case, the unusual result arose because at the end of the day, there was little or no tax payable, but about $7 million of interest. So a very unusual and curious result. So I think the takeaways here, and we started to talk about this immediately, was actually just as a protective measure, if you're going through these kinds of multi-year, almost multi-decade audit journeys, whether at some point making a request to carry back losses, even though you may not know when you need to use it, could be a kind of protective position. And on the issue of national importance, because I think we all need to sort of figure out where the Supreme Court might be going with all of this, I would direct anyone who's interested in following up, go take a look at the factums for both parties on the leave applications. And that will give you a sense of the statutory interpretation issue that's at the heart of this that the parties had identified. And they're very, very good on those points. And you read those and you get a sense actually of what it is that the court might be doing in terms of wanting to say something about statutory interpretation and tax. And I don't mean this to be disrespectful in any way whatsoever, but actually the responding position of the government, even though they're saying there's no issue of national importance here, when you read the nuances of the responses in the responding factum, it actually shows quite a lot about the importance of some of the statutory interpretation issues here. So it's curious that both parties might have actually sort of revealed to the court that this issue needed to be addressed by this Supreme Court in the context of a case that otherwise looks like a narrow issue relating to the calculation of refund or interest on an unpaid amount. I'm going to skip through, in the interest of time, the Darcy case, but this is a very, very recent tax court case on GAR. And again, thinking of the post Dean's Knight framework against some of the jurisprudence that arose beforehand. This was a puck averaging case, and we commend it to you if you wish to go take a look. So now for the AI portion of the discussion, I did this last year too, and I feel like the AI portion of the discussion becomes like the third guest on a talk show. So I'll try and
it's your favorite topic, Tim.
Well, it's such a rich area. It's such a rich area. I mean, it ties into what the CRA is doing in terms of its enforcement and the resources that it has. It's an area of which there's tremendous change. It's very dynamic. It's incredibly interesting as well. I just as an aside for some humor here, for those who saw my presentation last year, I included the picture on the left side of the screen when I did the AI image prompt, nerdy tax lawyer. Well, I tried to do it again to see what we get in 2025, but of course there was a misspelling in which I put in birdie tax lawyer, and so in 2025, inputs equal outputs. It's still the same principle in some way. So that's where we get a little bit with some AI. Again, we've included here a whole bunch of references relating to what's happening in the area of AI. There's some great stuff that's out there. The McKinsey report from earlier this year talks about how very large organizations, large corporations are really leading the way on using AI to transform their organizations. The StatsCan report out of Canada, probably because our business population trends towards the small to medium size compared to the business population that McKinsey may have looked at, but it was actually showing a little bit less uptake in terms of the Canadian businesses that were studied here. I tried to find the data underlying the StatsCan report, but it wasn't available where I could find it. Just this week, we're having Wall Street Journal reports about OpenAI's plans, and you can take a look at what they're building down in southern parts of the US in terms of these data centers and the advances in the technology. It's incredible. ChatGPT apparently up to 700 million users a week. And just this report yesterday on CNBC that AI program can now pass the CFA in a matter of minutes. And the reason that's interesting is I think the last time they were trying to do this, the researchers that were studying it, AI could pass the first two levels of the CFA exam, but it could never get past the third one. Well, now that's done. It's almost as though, Deep Blue is beating Kasparov in chess matches, and we're watching this all unfold in real time. So let me just quickly go through the rest of this. We're starting to see some discussions from various international organizations about how AI is going to be used by tax administrations around the world. And so I've included some of the references here for the articles that we have found. The IMF's getting in the business. There's actually a website called taxadmin.ai relating to the European Union and sort of tracking what it is that European Union member states are doing around their tax administration and the use of AI. The OECD has a report from earlier this year about some of the ways that AI is being used in tax enforcement and government functions. And essentially, you're talking about either enforcement or service. And so we see that it can kind of break down along those lines there, that you have detection, evasion, fraud, et cetera. And then the virtual assistant side sort of tips over into how to improve customer service with your stakeholders, namely your taxpayers that are trying to get information and are just trying to file correctly. I've included some examples here. Again, France tax authority using AI to take aerial photographs and comparing it to some property reporting. File assignment in Brazil, decision trees in the Austrian tax authority, Singapore using a tax chatbot, again, customer service being the goal there. And then Australia apparently using a sort of refund integrity type approach to determining using machine learning and AI to figure out how to do this. Here's some factors identified in the OECD report about how to move this forward and what the guardrails are. The CRA's departmental reports have started to refer to artificial intelligence starting around 2019. Prior to that, it really wasn't in any of the previous reports, but now it's showing up in each of the annual reports for the departmental plan. And we can see here that the CRA is echoing some of the international trends, namely reviewing activities, detection, prevention, verification, use of chatbots to improve customer service, and in light of some of the things that Marie-Claude talked about off the top of the call relating to resource challenges, maybe some of these technologies will be used with more frequently in CRA operations. Canada's Artificial Intelligence and Data Act died on the order paper in January. It has received some criticism from some people about not being sort of appropriately thought through. I've included here a couple references for our accounting friends who joined the call. There's some sources in terms of CPA and CPA publications around the impact of tax for accounting. And in the law space, just a reminder that Law Society of Ontario, as some of the other law societies as well, are publishing guidance for licensed practitioners about how to deal with this, how their firms can manage it, what the appropriate guardrails are. And so there's some resources out there for people to take into account. Now, this is great. So there's a guy down in the U.S. named Damian Charlatan who has a website, and if you just do a search for his name and AI hallucination cases, he's actually tracking around the world all of these AI hallucination cases. This being one of the biggest concerns about the use of AI in the law area, namely that large language models just they create responses based on likelihood of being correct. But it doesn't always mean that everything that they're giving to you is actually correct, or that it's actually something that was based on a source. It's more predictive as opposed to actually being actually 100% correct. So there's 302 cases from courts and tribunals around the world, 27 of which are in Canada. And the Zhang case is a very famous one. When you look at these cases, many of them are self-represented litigants who I believe are probably resource challenged. They're just trying to manage their cases. They're using a tool that they thought would be helpful in terms of what they're doing, but the courts have said, hold on, this is entirely inappropriate. So now the courts themselves are starting to publish guidelines about appropriate use. The federal court has a very detailed one. And in fact, the rules of civil procedure in Ontario have been changed. And I expect that we're going to see this in the federal court's rules, likely in the tax court's rules, or at least in a practice direction, where counsel or experts are required to actually provide some sort of affirmation acknowledging the use of AI if it was used in the production of some sort of material that was submitted to the court, and an affirmation or attestation that there was a human review that took place and that actually all of the information has been verified and is correct, so that the court can be satisfied that we're not sort of concerned about those kinds of problems that have arisen around hallucinations previously. All right, I know that we're right at the top of the hour. Let me just say 2 more minutes here on the use cases. I have found the use of AI tools in my practice to be incredible. The data and computing power and its impact on the litigation and dispute process, I think, is potentially incredible. I'm talking about tasks that I was able to take from what previously would have been a couple of days of work and getting it to a good point in the work process within hours. So the use cases are incredible. I was on a call yesterday with a commercial provider of an AI tax research platform, and again, the results are absolutely incredible. But I've included these 2 cautions here because the first thing I did yesterday after hearing this presentation is I walked down the hall to one of my partners and I said, "What are we going to do about how we train people to think critically while these tools are available?" Because we don't go back to the books anymore, but we still have to research, and we have to be able to think critically, and we have to come up with the right answers, and we have to be able to advise, and we have to figure out how the law is going to work, and we have to figure out how to respond to the CRA. And if these tools have a tendency to take our minds and our critical thinking skills in a different direction, we could have some challenges there. So that's an incredible one, I think. All right, we've hit the top of the hour. I apologize for going a little bit long. Marie-Claude, do we want to make a couple of comments with our audience's indulgence to continue for a couple of extra minutes?
I just want to say one thing. Until CRA is fully AI governed, we still need to look at best practices to handle audits. And there's one thing that I've seen in the last year that is essential is that you need to take the auditor by the hand and make sure you communicate with them and explain the documents you send to them. These are just my parting last thoughts. I've seen too many unusual audit activities in the last year. We've provided some examples on the slides. We won't go through them. So just ensure that you keep track of where the audit is and keep an open communication with them. So we want to thank everybody. Tim, I think you had a couple last words for our audience today.
Yeah, I mean, we've included a few slides here. Again, we've covered a lot and we really kind of went through it quickly. So thank you very much for choosing to spend your time with us. We didn't get any questions come in, at least that I saw, but of course, both of us are available If you would like to continue the discussion, I'd love to talk about AI and tax and where we may be going. So give us a call. We're happy to chat with you about anything that we talked about today. And again, thank you very much for joining us, spending your lunch hour with us. Thank you. We have the codes there to the extent that you wish to input this for CPD requirements. And again, thank you for your time today on behalf of Marie-Claude and I. And Fasken, thank you for joining us for our quarterly update on tax disputes.